Welcome to the Dams Policy and Buildings Policy Consultation Panel. We've got Trudy and Campbell and myself to deliberate on submissions for this updated policy. I invite the staff and officers to come a bit closer. Can't stay out of the camera. So I'll just start formality of it. There's the housekeeping, there's no apologies. Order of business is as we've got there. We've got the dams and then the century buildings. Straight after that, that's a two parts to it, I believe. Sort of one and the same, but being brought together. I'll get there's no interests, but I'll ask both Bruce and Mandy just to kick it off. If anything, I've read through the report, which was very helpful. And it seemed not so long ago when we council put together a panel, and it seemed not so long ago when we looked at redoing it. And that was 2020 from the last policy, and then 2006 policy for that, if I've got that correct.
That's correct, yes.
And just to clarify, we've gone out to consultation, which was great, but I see we had no submissions as such. I put that down to the fact that people felt it hadn't changed materially at all from previous, but saying that there's a few things to go over today.
That's correct. There were no public submissions. There have been some minor changes made. There was I guess consultation with iwi. A couple of hui were held.
Yep.
And as a result of that, the draft policy refers more specifically to the Kia Kotahi Te Te Ihu Together partnership.
Yep.
And further through the policy, it referred specifically to treaty settlement statutory acknowledgements that are applicable in Nelson. And then also to be consistent with the dangerous buildings policy, there was an addition of explicit reference to the Local Government Official Information and Meetings Act and the Local Government Act, just pointing out that the requirements of that legislation would be met in carrying out the policy. Otherwise, there is just some. At the end, there's a reference to the Nelson's resource management plan, and to the Kia Kotahi Te Te Ihu agreement. Are there any questions?
Thank you for that. There will be. I've got a few.
Yeah.
So you described it well. Can you? I mean, I read through this, and then I've said flick through 2020 and 2006. From my understanding, was there changes? What we went out with? Were there any changes to the previous policy, 2020? Was it apart from what you're bringing to the table today, apart from consultation of iwi? That's pretty close to what we had before. Or just give a background for the reason why we decided to redo this policy or
okay, yeah. So just two policies going through here: the dams policy and the buildings policy. And I didn't pick it up when you mentioned earlier.
Yep.
So that the dams policy was adopted in 2006.
Yep. And
then in the intervening years, there was no effective review or replacement of that up until now, in effect. So the 2020 amendment refers to the buildings policy. That's not in this one. The reason for that delay is that there was no complete legislative pathway authorising the policy. Regulations under the Building Act were approved, were repealed.
Yep.
and it took some time. So there are regulations for dams that came out in 2022, setting out some fairly specific requirements that differed from what was applicable in the 2004 legislation.
Yep.
And so for that reason, this current draft policy is a complete replacement of the 2006 dams policy. I think one of the key changes is that council's role is no longer to identify dangerous or earthquake prone or flood prone dams, because it's not expected that councils will have the expertise in-house. So all of that responsibility for identifying risks and hazards and statuses of dams sits with the dam owner, and they contract out to a recognised engineer. And that's a recognised engineer as determined by Engineering New Zealand, their registration board. So council is really, I guess, an administrator, making sure that dam owners are providing documentation on time and taking action, and council can also issue notices and require works to be done.
So from my reading, that's really giving us some rules, guidelines, we feel that dam historical or has some concerns areas that we need to mitigate, gives us as a council. Oh, sorry, microphone back on. My understanding then, going through the report in detail, was that if we got dams that have potential risks, or there's going to be landowners making changes to them, so even upstream, also downstream, that we've got some levers to say, hey, you need to monitor this, or we need to do some, letting the community know what those risks are, whether it be on LIM reports or giving some guidelines in regards to the measures to request the landowners to do, and then take those steps further. If I've got that correct, which weren't there before necessarily.
Yeah, sorry. I think that's absolutely correct. So there's a building consent process, which is quite separate to the policy, and that relates to permission to, and I guess the resource consent process as well, permissions to do works and build things, and the policy relates more to making sure that dam owners are providing the required paperwork to council in a timely fashion, and that any issues that are identified are actioned appropriately, and that the public and affected parties are notified and informed of the situation.
Cool, thank you for that. And I'll just also, before we start questions, just outlining, I was looking at the map, etc., and we've got dams such as the Maitai, the Roding, and there's some little markers in that map there. Many of the dams are in the sort of small dams, are in the Tasman region, but what sort of scale of dams have we got that come under? I'm sure a lot of people wouldn't realise until you go over the brow of the hill to see a small water retention for a farm or so forth. Have we got many in this region apart from our water supply?
So primarily the dams that are primarily affected by the policy would be, I think we've got 4 larger dams. There's the Maitai, York Valley Detention Dam, the Roding. Next one is, and then there's Rains Dam, which is a privately owned dam. There are a number of other smaller dams that are unlikely to come within the regular reporting requirements of the legislation, but they do come under the policy because even a smaller dam can be classified as a dangerous dam if it meets certain criteria. So all of those smaller dots on the map could potentially be caught up or covered under the policy. But they're probably not they're not going to come under the regular monitoring requirements.
We're a dam of 20,000 cubic metres, I think, was it? That was when it's kicks in.
That's where the large dam definition comes in,
Okay.
and that regular reporting requirement comes in.
Hey, thank you. That's given us some more clarity on that, and sets us up for any questions on detail. And I've got Councillor Rowley, the first one.
Thanks, Councillor or Chair Skinner. Thanks, Bruce and Mandy, for the report. I think that the lack of feedback from the community sums up a very good report and very well written. So well done on that. I was just going to ask. I've got two questions, and one of them was around in your verbal talk just before you spoke around Engineering New Zealand. Are they a body that we would normally go to for consultation on this sort of work, or are they more just an association that people belong to and they're free to submit to council whenever? Is there a question on that?
So Engineering New Zealand is the professional body that I guess professional engineers in New Zealand are expected to belong to. I suggest not all of them do, but if an engineer is carrying out work that requires them to be a chartered professional engineer, and so that's most building work that's beyond the scope of typical small timber building construction design work, then they I guess expected to be a member of Engineering New Zealand, but they are required to be I guess registered, approved, pass the test for the Engineering New Zealand Registration Authority. And then perhaps on top of that or beside that, there is another category of engineer that is regulated, and that's a recognised engineer. And a recognised engineer is recognised in the sense that they have expertise in design and management of dams. And Engineering New Zealand manages the registration authority for that. So that is embedded in legislation in some way.
Yeah, cool. Thanks for that. And I just had one question, and I'm just going to try and give you the page, because if I read it out, you'll have no idea where I'm talking from. But it's under the number 4, policy principles of dangerous dams, earthquake-prone buildings, attachment 4.1.1. And it was just around the wording there under policy principles A, and it said, council will endeavour to communicate to dam owners about the responsibility of dam owners. And I just wondered there, is it in terms of if we have, we obviously know we've got people with dams in the community, would we not be always talking to them, or is it more we'll talk to them when we need to? I was just thinking around the wording there, around what their responsibilities are, and thought, do we need to have it a bit more, I guess, set in stone that council will talk to them, or is the word endeavour enough in this the principles of the policy? I know it was very small, minor, but when I was reading through it, I saw it and I thought the word endeavour can mean a few different things to me, and I just wondered if we needed to look at the wording there. Happy to be guided by your expertise, though.
Yeah, that's a good point you raise, and I probably need to think back into the history of that. So very much the wording in that section was modelled on a template policy that was put together by a collective of councils through New Zealand, so that we could all sort of start from a similar spot. The challenge is that the legislation puts a lot of the responsibility for day-to-day management on dam owners and not on the council. So to some extent, our powers are limited there. And I think the objective was to try not to make it too much council's responsibility. You know, if a dam owner is responsible for knowing what, under the law, is responsible for knowing what they need to do under the legislation. And if a policy, I'm surmising here, but if a policy is worded such that council will tell owners what they are supposed to do,
Yeah.
then that perhaps puts too much or potentially attracts liability to council. Some owners are not receptive to receiving information, and
For
so I guess it's the best endeavours.
No, that's fine. I just saw it there, and I just want to make sure that we're as a council, and in particular the staff who deal with the community on these issues, we've given ourselves enough leeway there. The final question from me is in terms of our neighbouring councils which have dams as well, how is this policy much different from what you would see in a Tasman or a Marlborough council in terms of their dams or their policy rather?
That is a good question, and I did look at their policies explicitly some time ago now, and I forget what the precise answer to that is. I think they're not largely different, but I would have to go back and have a look and see what the specific differences are. There are some differences, but I don't think they're substantive.
Thank you. I'm sort of just going to follow on from Councillor Rollo there about the owners, because it was on page 31 of the agenda report with 2.4 and 2.5, where it talked about identification of dangerous dams, and then it was about response to complaints and dam documentation. You sort of half answered based on Councillor Campbell's question, but I sort of want to pluck out 2.4b, where it says inspect each dam when necessary, and then 2.5 when it says why wait for complaint, because it says high or medium category, but there's no low impact category. So you've just mentioned that a lot of the reliance is on the dam owner, and that it's to take away from the councils now, and it would most like, you said it before about no longer expected councils have the skill and knowledge in-house and can outsource, so we become the administrators. But does that actually cover it enough, like for the assessment, or should it be done more regularly based on what is worded in the document there under 2.4 and 2.5? I sort of feel like there's a lot of good faith on the dam owner, but there's no real regular, which is sort of what Councillor Campbell was sort of tapping into. There's no regular process. It just sort of talks about a lot of reliance on the inspectors.
So I think Mandy's just showing me. So yeah, 2.4, 2.5. So I guess just speaking more broadly before I actually look more carefully at that. So low potential impact dams are not subject to the requirement for regular reporting, and I guess because they're a low potential impact, they're a lower risk. So the legislation is providing that leeway, or if you like. And then under 2.5, yeah, so sorry for the delay. So if I understand your question correctly, 2.4, 2.5 says council's going to pay attention to high potential impact dams and medium potential impact dams, but not low potential impact dams. Is that?
Yeah, because it just talks about the high and medium categories, but there's no reference to any low impact or saying that they're excluded or what is defined.
Yeah, and that's because the legislation excludes the low potential impact dams from that closer scrutiny.
Okay. But I'm just trying to get at, but this is enough for the regulatory requirements because we're just really heavily relying on the owner to advise?
Yeah, so there are quite strict requirements, if you like, under the legislation. Dam owners were required in the first 12 months. Actually, there was a sliding timescale depending on the dam to notify council of the potential impact classification of their dam. And pretty much all dam owners have done that. And then depending on the outcome from that impact classification, they would have either 2 years or 1 year to provide a dam safety assurance program. If they were high impact or medium impact, and low impact have no requirement to do that. The requirement on low impact dam owners is that every 5 years they must supply a review of that potential impact classification. So while there's much less scrutiny of those low impact dams, it doesn't go away altogether.
So is there a requirement, say like the storm event that happened in 2022, is there a requirement that they would then have an assessment to see the state of their dams or if the classification changed based on what happened through the storm event?
Yeah, so the legislation allows for that possibility if something, if council has reason, council officers have reason to suspect there's a problem, they can require that the owner provides us with a review of that dam status. Of course, during an emergency event, a declared emergency event or a designation, then the policy doesn't actually apply. There's a different section of the Building Act that covers emergency management of dams. And I've included, it's included in the policy there that council officers will actually consider what is the best part of the legislation with which to deal with this dam and make it fall on emergency declarations, considering that.
Okay, no, that's right. So
try to sort of make it explicit that we will make that conscious decision.
yeah, no, that's right. I was just sort of tying it back to when you said before that it's not expected that councils would have the knowledge or skills in-house and would have to contract out. So there was a lot of trust and a lot of other factors sort of weighing in on that. And I'm just going to park that, process what you said on it. But I want to come to page 37 with your risk assessment table, Appendix 1. And again, a lot of my questions sort of relate to what happened in the storm event. So I'm just sort of like trying to, weigh that up. So the moderate rating, is that too narrow, or do you think that that's wide enough? And I'm going to give you the information why, so you understand why I'm asking this question, because it talks about the housing and the damage to a house, but what about industrial areas, or the mix between the commercial, industrial and residential areas, and what happens when a road is damaged and that network to those housing areas or everything is affected, like that moderate rating, does it cover that? So like, how long is it expected for that roading network to be fixed or managed so that housing area that may have had that damage also so this is where my thought process is around this moderate rating. And then also what cost or impact is then viable, because is it robust enough for the infrastructure and the roading around those housing areas as it is documented? So I'm just trying to ensure that the intent of the table in the moderate risk assessment, and that actually carries forward regardless of who sits in the seat at council at the time, so that the intent of the policy is still consistent and matched.
Okay, so the low impact medium impact and high impact are set in the legislation and regulations underneath, so we don't have any discretion on that. I don't see if page 37, there's a page 34 seems to be the
No, it's the main agenda, Appendix 1, the table.
It's Appendix 1 that we're looking at.
Oh,
yeah. So I'm just looking at that page, Appendix 1. That is a part of the original policy from 2006. That is the current policy, but is proposed to be replaced.
Yeah.
So that's no longer applicable.
So that table. Oh, okay.
Yeah, that's the policy.
So that's not what's referred. Okay, I got myself confused then because I thought it was still referring to that in the adjustments. All right, I'll cut that. So then the climate change, it's referred to throughout the document. Does that need to increase in percentage per year based on like latest river events or risk periods or things like that? Does that need to be altered? Because it's not targeted specifically in the policy document, but it refers to it throughout.
Yeah. So I think detail at that level is probably covered by the New Zealand Society of Large Dams technical guidance, and that is a document that has been updated a number of times and will continue to be updated. So I think that's too much detail for the policy. Yeah.
That's right, because it was just implied throughout the document. So I was just sort of wondering, again, I'm just basing it all on our 2022 event that happened and where we were at as a region.
Yeah. And so once again, the policy is more or less for business as usual management of dam safety. When there is an emergency event, there are separate. There's a separate section in the Building Act.
That's right, because it moves back into business as usual.
Gives councils broader powers.
Yeah, no, I'm just sort of talking about when it moves out of the emergency and then back into business as usual. It's that sort of transition period.
Okay. And so in that transition period, once again, that the policy talks about council officers will consider whether it's better to keep a designation in place and deal with it under the emergency management procedures, analogous to the red, yellow and green placards for buildings, or whether it's better to deal with it under the business as usual section of the Building Act, in which case the policy would come back into effect.
Cool, thank you for that. I'll just also remind the panel also that we're here to deliberate on submissions, and as much as we probably might see now stuff we want to change in there, this is what we've gone out and submitted on. So I'll just remind the panel we can only really change or reflect on stuff which has been brought to our attention to be changed by the public on this. But obviously if some clarity or if we think something has been overlooked, by means. So it puts us in a, I wouldn't say strange, simple or difficult situation, because we've had no submissions, and I take that as they're very comfortable with what was put out for consultation, and I put that also down to they had a good understanding. Those this would affect directly would have must understand the previous policy. So would that be correct in saying without submissions coming back formally or informally, but to officers from interactions with landowners and dams, etc., would I have been correct in assuming that we've had no submissions, people very comfortable what was in the policy, anything had been changed or reinforced, and that they had an understanding of the previous policy? Or has it just been, or do we think we haven't reached out as well as we can do as good as you can, but it hasn't reached to those affected?
I think we reached out quite a few. I mean, council itself is our majority in terms of the high risk, high impact, high potential impact dams. Council is the primary owner of dams, and so I've reached out to our teams.
So I wasn't meaning to disrespect you're not in contact. So I'm really leaning on you guys because you guys are in contact with landowners and structures, more so than we are, and we're relying on that feedback from the submissions. There haven't been any, but would your understanding from your line of work is that in contact with landowners over the years that they're comfortable and they understood what's gone out today?
Yeah, I think
yesterday.
the legislation has been quite a change, and not so much. I mean, there's been very little come back to me, within my role in council, but I know, in the media, rural landowners have been concerned about this, and the government made changes and what have you. But I haven't had any particular feedback. I guess we've got one owner of a significant dam in Nelson, and he hasn't given much feedback either way.
Okay.
I guess you could say too much regulation.
Yep.
But
So giving feedback here on
nothing substantive on any particular aspects of it. So
cool. So I think that's. I mean, it was a very good report, and it's as you say, it's also given us an opportunity to make use of that consultation experts on such engineering if it comes to that situation. I'm comfortable what's in there, and obviously I'll wait on the feedback from my colleagues here as well. And as I was saying before, that having no submissions on that, I'll sort of take as a good sign. There wasn't anything in there that said, well, I think we've overreached or underreached. But on the other side of the coin, I see we are making some changes to what we submitted on. And that was with the iwi, we didn't get any feedback submissions from iwi, but you've gone out and approached iwi as in good practice. And so the only changes I understand is a small portion there, pretty much saying, bear with me, on 5.8. No, sorry, not 5.8. 6.1. In regards to leading, wasn't 6.1, but I saw it highlighted in yellow, relating to that if we had any concerns with a dam's safety or so forth, they'd be contacted iwi in regards to ensuring that environment and the effects it would have on them. My question is, or statement is, well, if there was an issue with a dam, it would have the same effect or concerns environment for anyone and everyone in Nelson that's directly affected by it.
Exactly. So I guess the policy says that we'll make any information about dangerous earthquake-prone or flood-prone dams public.
Yeah.
And I guess we also specifically call out FENZ, Fire and Emergency New Zealand.
Yep.
And I guess we have an agreement with iwi, so and they I guess have an interest in quite a bit of land in Nelson. So
so that's sort of
perhaps it's reasonable that they hear from us first rather than hear via the media.
I know that sums up well in regards to land ownership or so forth. Approaching them as would anyone's land is owned, and also see heritage and the heritage part of it as well. If you felt that
that's right,
lost a certain line or potential or good, bad, ugly heritage would be contacted.
I don't believe we have any heritage dams, but
no, okay.
No, I mean there's some old dams with heritage value.
Yeah,
and it's just a matter of do they pass that threshold? Are they actually on the heritage register? So we don't have any. But
and quickly on that be only dams that are functioning. I mean, I think of this up at the brook there, Waimarama, you got the old, one of the oldest dam in the New Zealand. At the head of that, not at the lower part of it, as the town has grown, it's gone up a bit higher. But would this only cover those dams which are functioning rather than a historical relic?
That's a good question, and that's something I'm exploring actively at the moment.
Cool. I'll just ask.
It's certainly aware of it.
I'll just ask the good work that you guys already do on that. On that sort of, it might be outside of the engineering side of it. but it's something that's obviously passionate. The public are passionate, I know, about the looking after those. And once again, if there's going to be alterations and changes on land, that as we do in heritage or community, no. But falling back on that, because there was 6.7, 5.8, you quite rightly mentioned that. But I think it's great, which what we've done in the past and continue to do is keep in discussions with iwi as much, as well as non-iwi organisations, stakeholders, and this has clarified this with land ownership. But I see in 5.8, officers have also identified there isn't any explicit legislative requirement to include this in this policy, and also look at the Te Tahiu arrangement earlier this year, which was really just reinforcing the relationship we already have with various iwi. And I see there's no real changes as such to the policy I see, if I've got that right. My concern is if we go after having no feedback from community, they're happy with what we've got. If we make a change and add to it, when we haven't had any feedback from it, then they'll say, well, this is different to what we signed off, in a sense, by not.
Yeah, that's a reasonable question to ask. I guess we've spent some time considering that. Perhaps
say the legal risk is low, is to identify some risk. I'm trying to. I don't see an issue here, but my first reaction when some changes happen, and then we'll go out and sign it off. Submitters would have submitted possibly if they'd seen what we've got here today. I don't think they will, but they could have. We don't know.
And that's a reasonable question to ask. I mean, I guess I don't have a good answer for that. Made some inquiries to see if there was, for example, a legal requirement.
Yep.
And none was identified. Doesn't mean there isn't one.
So I think the answer really to that question is in that first resolution to council.
Yep.
That the changes do not fundamentally change the document that was consulted on. Yes, and they're very minor changes. So, yep.
Yeah, and I get some comfort in that, and that will need to be expressed, and it will be expressed at the meeting coming up on the 1st of May, etc. And looking up, if I missed anything, the changes is basically saying we will, well as FENS and Heritage, if it clicks that box, we'd let iwi know because we feel there's land ownership will affect our environment, etc. I reiterate that would affect whoever owns the land, etc. But as you stated, rather they heard first before other channels.
That's my feeling on it. Anyway, yeah.
And I see iwi haven't given any feedback to any changes inherent in the way we've drafted this or the way we go about securing the safety of dams. It's just in regards to communication after the fact.
Yeah, my understanding is communication, and I guess giving them an opportunity to feedback concerns they have.
No, that's very wise. So no, that puts my mind at rest. I think that I'll just ask if there's any other comments or questions from my two colleagues. And I'll just sum up and not sum up. The only other thing I'll lean on you again as well is because there wasn't any feedback, and obviously this was a reinforced policy gone out. Is there anything in here that you think that's a bit too light, or in hindsight or down the track would need to be looked at further?
No, I think as you see, there are a couple of small editorial changes in there that were made post-consultation,
yep,
in addition to those that we've talked about. And so, that's my clearing up of any reservations that I might have had, if that makes sense.
Thank you. And last, I know I've spoken a little bit here, and it's outlined here also in the Te Tahiu document. iwi's interests in the greater picture was this regional strategy, and also we're looking at dams in the local region. this all dovetails well to our neighbours in regards to Tasman, Marlborough. Marlborough's over the hill, but our water catchment areas, dam owners, once again, in regards to, I tend to think more of that rural would have the smaller dams, but this all dovetails well into policy outside of the region, do you think?
I don't know the answer to that, but I don't see any reason why it would not.
I can't see any issues,
Yeah.
but I'm not the expert.
No, we're all sharing the same legislation. We're all sharing the same sort of template policy that came out from councils. So, yeah, there's no reason why it won't be aligned.
Thank you for that. That's very good. I haven't got anything more to add.
I'm good. I'm fine.
What I'll do is, if the officers are happy, no more questions there. I doubt there'd be much debate. I'm happy for one of you guys if you want to move what we've got in the recommendation.
Yeah, we'll move it.
Moved by Councillor Rolo, second by Councillor Brand. Any comments, debate, or other?
No.
No, thank you. So I put it. Those in favour?
Aye.
Aye. Those against? Carried. So thank you for that. So that moves on to the next topic. I'm pretty sure I just thank you for that. It was a very good report, and I don't claim to be a damn expert at all, but it gives an insight into the wheels of motion, Council. So the next one is the buildings. I'll grab the document. I'll use another big document. Can you just an outline for those of watching this? What is affected in sanitary buildings? What's that all about? I mean, I understand it because I've read it, but for the sake of those watching the public, which is what we're here to work for, I see this has been tied in because of the relationship with dams and buildings. They sort of overlap in policy. I assume that's why we've got both together.
That's correct. I guess the legislation, the regulations requiring the dams, enabling the dams policies to be reviewed, came in 2022, and it coincided with our 5-yearly requirement to review our buildings policy. So the policy is the dangerous, affected and unsanitary buildings policy.
Yep.
It was consulted on in October 2024, and we received feedback in the form of one submission from Heritage New Zealand.
Yep.
And we also had Hui with iwi, and they had very similar comments to what they had for dams.
Yep.
And also following that consultation, staff have made some other minor edits, mainly editorial, to the draft policy. What does it mean for a building to be dangerous, affected?
Yeah, it was for the lay person.
Didn't answer the question, sorry.
That's all right.
Okay, so a dangerous building is a building that is likely to cause injury or death in the normal course of events.
Yep.
Or injury or death to a person escaping from a building during a fire.
Okay.
An affected building is a building that is adjacent to or near a dangerous building.
Okay. Yep.
So I guess there's a judgment call on that. Just because a building is near to a dangerous building doesn't necessarily mean anything bad is going to happen in relation to that building, but I guess it gives council officers the discretion to designate a building an affected building, and perhaps require people to not use that building. And an unsanitary building is a building, I forget the word for word definition, but basically a building that is unsanitary or offensive in some way. Some of the definitions, sub-definitions of unsanitary include, for example, that it does not have a potable water supply,
Yep.
or that it doesn't have sufficient sanitary facilities.
Okay. And this is over and above what the building would have to be consented to operate in its function or build. Is it these are primary buildings that have been left standing and unused, or was it more than that?
So I guess it's if you consider a fully compliant building having sanitary facilities and enough structural integrity to stand up and not fall down, this is a really low bar. Buildings have to be quite bad to be considered dangerous or unsanitary. Does that answer?
Yeah, no, it does. It does, and I can understand and appreciate the input by the Heritage. Is it Nelson Heritage or Heritage New Zealand in regards to dealing with heritage buildings? There's some incredible buildings and structures. They may not even be complete, but they have a huge heritage interest. And is this where this kicks in? You might have an old farm building, or Grampians there, you had an old brick, that was corrugated iron building that used a bit of a sharing shed, but it wasn't no longer being used, etc. Must have been going back to 1940s. And I know at Walker, we've got one of the most original sheds, I think, out there. It's probably not functioning anymore. They put together as a kit set, brought them on the first ships. All effort is to retain those structures. This, I assume, this is where the concerns of the heritage.
Yeah, that's correct. I guess our policy as consulted was fairly brief on heritage buildings. I think there were kind of 2 sentences. Officers had considered that was sufficient. It was in line with what was in our current policy that was amended and adopted in 2020. Heritage New Zealand felt that a lot more detail was appropriate. Just reminding us of the principles and various aspects. And so, on reflection, we adopted not word for word what Heritage New Zealand proposed, but certainly took on board all of the ideas that they had, and there was dialogue back and forth until we had a mutual agreement on what was appropriate.
And that council with that what's gone in.
That's correct. I mean, for example, there was some near the start of their suggested text, I'd suggested, I think, that the Nelson Resource Management Plan was perhaps a primary guiding document for how we would handle heritage buildings. However, this is a policy under the Building Act, and the Building Act includes a principle that talks about preservation of heritage, and so officers felt that it was more appropriate to refer to the governing legislation for this policy than to a separate piece of legislation. So those are the kinds of...
So do you think that's in regard to a structure or so forth that may not be used anymore, but it might come under this as being potentially dangerous or unsanitary? It would be a case of feedback, is it, from Heritage New Zealand to have that more conversation with the owners and council on the best way forward to remedy? And is it also saying, which I don't see it here, but I might have missed it, is it also saying to communicate that to Heritage New Zealand or so forth, is it?
That's right, I think, yeah. So our
give primary... to just say, hey, we can do something about this, or rather retain it if possible. Is that what it's about?
Yeah, so our primary response is to talk to the building owner and the occupiers and find out what the situation is, and to see if we can get any issues addressed there and then, or without needing to take regulatory action.
Yeah.
Sorry, I lost my...
That's right. And it was also an opportunity. Is that an opportunity I'm sort of teasing out? This is new added, which I think is good. And understand I've got this right. If there's something that's about to be removed or changed or so forth because of concerns council, landowner has, we give the opportunity to communicate that to Heritage New Zealand, and they can say if there's a real value in that. Could be an old sharing shed, for example.
Absolutely, yeah. So we communicate with owners, occupiers. If it's a heritage building that's listed on the New Zealand heritage list, then we are required to go back to Heritage New Zealand and get their feedback. And that was included in our previous policy as
Okay.
well. So there's no change in that.
So what we've got in yellow here on, say, my page 55, that's really reinforcing what's already part of their previous plan, or what were they feeling?
That's right. I mean, I guess the original policy, the current policy talks about that very briefly.
They felt it wasn't.
I guess sitting under our policy are our operational procedures, and I guess it is spelled out in our operational procedures that we need to talk to Heritage New Zealand, and I guess that change that Heritage New Zealand have prompted us to make is that it's explicit now in the policy that we will talk to them.
Cool. Hey, thank you for going through that, because it's quite an area I take a lot of interest in. But I'll hand over to Campbell and Trudy if there's anything they want to ask.
Yeah. Thank you. I just got a brief clarification. It's sort of on that around the council's approach to performing its functions. It's like on page 4, it's like 5.1E, where it says consult with the environment health officers, medical officer of health, or health protection officer as appropriate. This is especially the case if occupants are considered neglected or infirm in accordance with section 126 of the Health Act. And then it's sort of, because my question sort of comes back to the insanitary or hazard of a building, which could be a home, which could be a person who has, I don't know, got a hoarding complex or things like that. So there becomes a danger to themselves inside. So does that clause there and 5.3, when it says the actions taken by council, does that mean that if we refer them to the Ministry of Health or a person in the health system or a medical officer, that's the only thing that we need to do? Because sometimes those people are quite resistant to people coming on their property or in their home, and it makes it quite difficult for the assessment to take place if it's been from complaints. Where does our trying to engage them with somebody to support them or assist them sort of start or end, is that just what E is? Is that on page 4 of the new 5.1 council's approach to performance function? I'm just sort of trying to place where it would be like, you know, we don't have social workers, we're not a social service agency, but these people need that sort of help if it's an owner-occupier, or if it's a different situation, it's insanitary because there isn't a clean water supply and things like that. Yeah, where do we fit in our role, and where does the onus on us to engage them with or ensure that they've engaged with an appropriate person for them to continue in that?
Yeah, so this is something that I grappled with a year or so ago, maybe a little bit more, when such a situation came up. Hoarding, for example. We have a very good compliance officer who's compassionate and tactful when they need to be, and then I guess in writing our procedures underneath the policy, the current policy, how do we remind staff what they can do in these situations rather than trying to make it up each time? And so we have a role, Steve Stiles, community partnerships liaison role. So basically down on the regulatory building team, we reach out to them. Hey, we have a person with this, and this. What services can we refer to them? What help can we get when we go to visit them to try and work through, is there an issue here from the Building Act point of view, dangerous and sanitary building, and what help can we be a catalyst for, facilitate for these people for services that council doesn't or can't provide directly.
So, yeah, that's great. I'm glad we do that. How's that reflected in like the actions that we take in this? Is in that 5.1E, or is that 5.3? Because I'm just trying to like understand where that fits.
Yeah, so 5.1E, consulting with the environmental health officer.
Yeah,
Okay, so
but
that's a
external.
role we have
Yeah.
internally in council.
Yeah. But what you just described, where does that fit in here?
Yeah, no. So
No?
it's more of our processes, because this policy is under one act, but one property could have a number of non-compliances under various acts. But we typically, as Bruce described, have all the people meet and talk about who's going to take the lead in this particular case, what makes most sense, what's going to get the best outcome for person, the property, etc. So,
But that's an internal thing.
It's an internal linking up. Yeah.
Yeah, I think it's embodied in that
But we
consulting.
won't lose that if we lose our good environment officer. That we're not going to lose that, or it's sort of like an in-house policy or process or something. Or
Yeah,
subject.
I mean, there's a couple of different people actually. There's sort of, under the Health Act, we've got environmental officers who normally would do Food Act inspections, but they also inspect homes from time to time for hoarding, health kind of issues. And then we've got our Resource Management Act compliance officers as well.
Yeah, I just wanted to make sure that we had captured that, and it wasn't just the tick the box thing based on we've engaged with them and they now deal with that. I just wanted to make sure this captured.
Well, the policy is under the Building Act, so it can only really capture steps.
Yeah.
That officers, when investigating that, will also consult other areas, but this is certainly a procedure under our council operating procedures.
Yeah, operating procedures, if you like, that we work to day to day. Have a couple of points, specifically pointing out, hey, watch out for this, and
No, I was aware of that.
These are agencies we can refer to. It's sort of specific down at that level, and it has been. Whether it's
I just wanted to make sure it wasn't an oversight that we had left it out specifically or something like that from here, that we still captured it, because I knew that we did it. I just thought it would have been more explicit in this document, that was all.
No, not the policy, in our procedures it is. Yeah.
Oh, thank you.
Well, thank you for that. That's very helpful. Anything that I'm really comfortable with this. I appreciate again the work done on that. I'm going to move it. And someone would like to second it. Seconded by Trudy. Go to debate. No, I think we're all very indication here. We're all very supportive of that. I appreciate the Heritage New Zealand submitting to that, because where possible is sometimes structures, buildings, or portions of buildings which have a huge heritage value. Especially as you get older, you suddenly take a real passion in how they came about, whether it be the old structure left over from the old dam, or this old shed, for example, which was one of the first kit set sheds that came over on one of the first boats out in Walker area, for example. And even though not functioning, they reflect the challenges of those who came before us. And often think of walking to school, and used to be the old brick down Toitoi Street, the old brick factory down Toitoi Street, and it was probably quite a dangerous building if you're a young kid running around and checking it out. And it's since been demolished, but those sorts of things, when they go on, you go, you hope that some sort of record has been taken, which they are, and it's good sometimes just to identify buildings if they can be retained or shouldn't be retained. And I also think of one that was removed at the Grampians, beginning of Grampians off Blick Terrace. There's an old shearing, I think it was an old shearing shed, or it might have been an old rabbiter hunting shed that would have been from Depression times. And there's an old car, I think, Russell car jammed in the hillside there from the 1940s, which had quite a story behind it. And it comes a time sometimes remove those sorts of things, but on the other side, it's good if they have got some heritage value that they're recorded and acknowledged, or appropriate things done. But often it's too easy someone to see something that looks like an eyesore, remove it, and then after the fact, you realise actually that had quite a link to the community. So I appreciate that. And as you say, this sort of get to the low bar of things with buildings by association or nearby an issue or safety risk have to be considered. But that's all I could add. So thank you for that. I've actually enjoyed reading these large reports on these topics. It's what I think keeps me interested in council. So those machinations that Joe Public and us as council don't know have to go on, and there's tens if not hundreds of thousands of these sorts of documents that need reviewing every now and then to make sure they're keeping up with the needs of the community. And I think that's what we've achieved here. And again, I like to think the fact we got no submissions, apart from the one to this one, showed that people were pretty happy with it. And if they're not happy with it, please let us know. But as you know, this will go out to, is it the 1st of May for our council to have a look at this as well. And another chance for the public to watch and input at that point as well before we sign off. But thank you again. Anything to be added by my two colleagues?
No, that's good today.
Very good. Appreciate it.
Have you got a second?
I have.
Yeah.
Trudy. I nearly had to flip a coin because I think you both said yes at the same time.
Yeah. Like Perkins.
I was weighing up. I've got to play football with Campbell later the weekend. But hey, I'll move it. Put it. Those in favour, aye. Those against, carried. Very good.
Thank you.